Good morning, everyone. Day 4. Any updates? Any housekeeping matters?
One or two housekeeping matters, which I'm going to let Mr. Brown talk you through, sir.
Morning, sir.
Morning.
Just 2 points from me. One is the updated inquiry document list, which we have a hard copy for you.
Yes.
That includes the speaking note from Mr. Johnston, which he gave yesterday. And indeed, the council and the appellant have worked together to provide an updated schedule of draft conditions. So you've got the draft conditions in at CD 4.5.
Yes.
What I'm about to hand up to you now sort of replaces that version.
Good.
Okay.
Good. Yeah. Yeah. That's the old ID list. Yeah. Yeah. Okay. Good. Thank you. Anything else? No, nothing else from the appellant. No. From the LPA?
So just to say that I've left a copy of Ms. Smith's summary on your desk, which I confirmed yesterday the council would print.
Oh, the summary of Miss Smith. Yes.
Yes, exactly.
Yes. Yes. Yeah. Yeah.
Okay.
Thank you. So today we're going to discuss the conditions on the 106 in a roundtable discussion, and then I'm going to hear your closings. There's nothing else, is there? No. Okay. So yeah. Right. So let's go into the 106.
So for the purposes of the 106 discussion, can I introduce, please, two people down from me, Miss Nicola Gooch, who's a partner at Irwin Mitchell, and she latterly took over conduct of the 106 negotiations with the council, and she's going to speak for us in relation to 106 matters.
Yes.
I think she also
Yes.
largely prepared the summary document that you have.
Yes. Good morning. Yes, I've read the summary document, which is very useful. A good summary. So Nicola Gooch, Gooch. Yes. Yes. Not the daughter of the cricketer. No.
No,
No.
unfortunately, no relation.
Okay. And you're from which firm? Sorry.
Irwin Mitchell.
Irwin Mitchell. Yeah. Yes. Fine. Well, I mean, I don't have any particular questions about the 106 because it all seems fairly clear to me. What's described in the summary is what's set out in detail in the 106. There's nothing that seems odd about it to me. It's just fairly standard 106, and it has all those details in it, including, you know, the timings of the delivery of various things, which all seems reasonable to me. Does the LPA have any? I mean, you agree to it. It's an agreement. So.
Yes, exactly. So it's an agreed document. Whether or not the council agrees with parts of the summary, for example, that there would be significant improvements to ancient woodland is another matter.
There's things like that in it.
Things like that. But otherwise, no, the council agrees to the section 106.
Okay. I think that was probably the briefest discussion I've had on 106 ever in any inquiry or hearing, but which is great. Good news.
So can I just note formally for the transcript, if there ever is one, that the 106 in its final form was put on the council's website, I think, last week, possibly Friday sometime. And so it's been available. And I think this was indicated during our hearing session on Friday. So it's been available for members of the public to have a look at in case they have any comments that they wish to make about it today.
Okay.
So again, if I may, just by way of reminder, I think I had previously raised and
2 weeks.
yes, 4 p.m. on the 6th of August. I'm just being reminded from my right.
4 p.m. the 6th of August.
If that's acceptable to you, sir.
Yeah, and obviously if it's finished before then, just send it as soon as it's finished.
It
So,
could very well be finished before then.
yes.
But if we have that as a long stop, that'd be appreciated.
Yes, that's great. So that's the 106. So on to the conditions. Thank you for the updated list. Yeah. So, Mr. Brown, do you just want to highlight what the differences are between the list that I had, that is CD 4.5, and the updated CD 4.5?
Certainly, sir. In the original version you had, there were 2 conditions dealing with ancient woodland.
Yeah,
They have been-
remind me which they are.
Well, in the update to the update, it was 26 and 27. In terms of the original version, just bear with me. Just turn that up.
I mean, I've read them all, but yeah, I think it's 26, 20, is it 25 and 26?
Right, so in the original version you had, dated the 9th of June, CD 4.5, we had the ancient woodland conditions were at number 25
Yeah,
and 26.
yeah,
They have been omitted from the schedule of conditions insofar as they are addressed by and in Schedule 5 and indeed the definitions within the 106. So there is no need to duplicate that by means of a condition or conditions. It's covered in the 106. So that's ancient woodland.
can I just take it, the LPA agree with that, do they?
Yes, sir.
Yeah, yeah, okay. Yeah,
And
okay.
the second topic, sir, is SANGs. So
Yeah.
the SANG conditions were, in your original version, conditions 28 and
Yeah.
29.
Yeah,
Again, for the same reasons as per the ancient woodland, SANG is covered in the 106, and you find that addressed in Schedule 4 and indeed in the definitions. And again, don't need duplication, so conditions 28 and 29 are struck out.
okay, that's very clear. Yeah, yeah. So there's minus 4 conditions from that original list, and there's plus 1 new condition, isn't there?
So, sir, there is plus 1.5 new conditions. So effectively, only if you turn to condition 23 in the new schedule, condition 23,
Yeah,
this, as you recall, deals with the replacement or reprovision of the 18 spaces from the Oast to elsewhere within the farm complex.
yeah, yeah.
And there are 2 versions of a
Okay,
suggested Grampian. For the avoidance of doubt, the appellant and the council had agreed version 1, but the council had additional thoughts and would like you to impose version 2, but the appellants think the first version 1 is entirely appropriate and suitable as a Grampian. And I think the parties are effectively asking you to conclude on the matter. Which version do you deem appropriate? The appellant thinks version 1 is entirely appropriate, is a Grampian, and the council think number 2 would be more appropriate and suitable, but I hand over to the council.
yes.
Thank you, sir. Can I just explain why the council considers version 2 is necessary? And it might be helpful to take up the plan 23138-017F, which is in the book of plans,
Yeah, the book of
highway plans.
Oh, you just bear with me. the highway plans, or is it one of the main plans?
I think it's,
Is it one of the main plans?
no, I don't believe it is, sir. It's in the milestone,
Yeah.
Sorry, Miss Hutton, was that 17F, did you say? Or?
17F, yeah.
Yeah, so actually, sir, it's also in MS4, if that's
Right.
easier for you to access. Matt Stevens' appendices to his highway proof,
Yeah.
MS4,
Either way.
either. So, you've got the Matt Stevens one towards the end of his appendices. You'll have a blue sheet with MS4 written on it in the appendices, and it's an A3 pull-out plan.
Oh, yeah, that one.
Yeah.
Yeah.
And so I'm also going to ask you to look at the planning permission at Miss Tucker's
Yeah.
appendix E.
E.
E, yes.
Yeah. Yeah.
So if I can just explain by reference to these plans. So the highways plan, 17F, shows in red the parking to be removed.
Yeah.
That sits within the red line boundary of this application.
Yeah.
But the red line boundary obviously doesn't extend over the farmyard, and the appellant does not have any ownership rights over the farmyard.
Mhm.
Two things need to happen in order for the reprovision of the parking. First, there needs to be an amendment to the 1986 planning permission, which sits in Ms Tucker's evidence. And so you've seen the condition, the relevant condition that required the parking to be provided and maintained.
Yeah, it's condition
Condition,
2. Is it?
it was condition 2, exactly.
Yeah.
And if
yeah.
one turns to the penultimate page of the appendix,
Yeah.
one sees the site plan,
Yeah.
but what one can see is that, and then it's in black and white, and we can't find a colour copy, but what appears to be here is a blue line and a red line, because the proposal was for rural craft workshops and an access, and one has that outlined.
Yeah,
and then
I
there's a
suspect
wider...
That's the red line. Yeah.
Yes, yeah.
Yeah.
So looking at this plan and the 017F,
Yeah.
the proposed reprovision sits outside of the red line of the 1986 planning permission as well.
Does it?
Yeah, so if one orientates...
Some of it does.
Some of it does.
Some of it does. Yes.
So, yes, I think the majority would do the blue park, the large areas of blue parking.
Well, it shows the oast and the building. So the oast and the area in that space between the oast and the building to the south of the oast, that's part of the red line site in 17F.
Yes,
But not all of it.
but not all of it. So some
Yes.
of it falls outside of the red line.
Yeah. Okay.
So that parking cannot be secured simply by amending the 1986 planning permission, the reprovision.
Okay.
It sits outside of the red line.
Okay.
The parties agreed there needs to be reprovision, but of course, and that reprovision should be not just provided initially, but provided in perpetuity.
Mm-hmm.
That needs to be enforceable
Yes.
by the council. So that explains the difference in wording of these conditions, because if I take you then to the council's proposed wording,
Yes.
so the parties are agreed on essentially the first two lines: no development above ground level, take place scheme submitted and approved in writing by the local planning authority, which secures. And then the local planning authority consider it's necessary to state through a planning obligation or other legally binding agreement which runs with the land to which it relates, the re-provision of the 18 parking spaces, and then reference to the plan and also the variation of the permission, and then the requirement to implement the scheme and to retain it. So it's to make clear that the scheme will have to be in such a manner as to be legally enforceable by the council in perpetuity. Because of course a scheme simply approved under this condition relating to land off-site would not be enforceable.
Okay, okay.
And then just to explain the second paragraph, it's really just for the avoidance of doubt what the submitted scheme shall include. And it's a plan, assessment of impacts on vehicular and pedestrian movements. And you remember that the Highways Authority hadn't been consulted on this proposal. So that was just picking up the need to deal with things like turning movements, etc. The legal mechanism by which parking will be delivered and a programme for implementation. So the second paragraph is just simply for the avoidance of doubt what the scheme will need to include.
Okay. Okay, so Mr. Brown, can you explain to me why you don't think, well, in particular, a planning obligation is required?
Mr. DePatrick will jump in on this one, sir.
Sorry?
I'm going to deal.
Oh, yes, sorry. Yeah, yeah.
So very briefly, sir, we suggest that the council is overcomplicating this and making it overly prescriptive in a way that won't be helpful, and that the first version, namely the one that the council first agreed, is entirely satisfactory and covers all the things that needs to be covered before they unagreed it and proposed.
Sorry,
number two.
first agreed. What do you mean?
Well, number one was originally agreed between us. Mr.
Right.
Redman and Mr. Brown agreed number one, and then the council unagreed it yesterday afternoon.
Because the highway people and the lawyers had a look at
So
it.
it's because the lawyers, exactly, it's the enforceability legal
Enforceability
Yeah.
point.
Yes.
Yes. Okay. Yeah. Yeah. Go
So
on.
that's where we are. There was a version that the planning officers were
Yes.
satisfied covered matters.
Yeah.
And of course that was an entirely practical, sensible agreement between them, because the enforceability issue is a complete non-point with respect. The council will not approve a scheme that isn't enforceable. It's as simple as that. If we give the council a scheme and they can't enforce the relocated parking arrangements, they'll throw it back at us and say that we're not going to approve this. So the whole premise of what was put to you was, if we approve a scheme and it then turns out not to be enforceable, well, the obvious answer is don't approve it. Send it back and say that's not a scheme per the condition. That's obvious. The council then, despite requests not to make it overly prescriptive, with any suggested tweaks to the wording of the originally agreed version, the council's then bunged in all this stuff about must be a 106, must be another legally binding agreement. There are all sorts of ways in which this could be dealt with. It could be a condition variation application with a 106. That would be a perfectly legitimate way of addressing this. But you could, by way of an alternative, and this might end up being simpler, simply do a new planning application for regularisation plus re-provision, with a new red line that covers the spaces to be lost and the spaces to be re-provided. And then that could all be capable of being secured through the terms of the conditions of that application, permission if granted. And there may well not be a need for any further legal obligation. So all this stuff that's been worked in to cover that situation just puts the parties in an unnecessary straitjacket. There may be all sorts of other ways of doing it, and that's why the first version, the originally agreed version, has more than sufficient flexibility to cover how we eventually end up thinking is the most appropriate way to deal with things. It covers all the concerns that the council needs to have covered, and it avoids overprescription and overcomplication. So that's why, respectfully, we suggest that the first version is entirely suitable, ticks all the boxes, and you don't need all the rest of this language. Thank you, sir.
Okay, can you just let me read through the first version? Just give me a sec. Yeah, so your point is a scheme for the reprovision of, yes, has been submitted to and approved and to vet, yeah.
Approval's obviously not automatic. If it's
Yeah.
a rubbish scheme and it doesn't give them the protections that they need,
I
they
understand.
send it back. It's as simple as that, really.
Yeah, and an application to vary the 86 permissions has been submitted to and approved to reflect this reprovision.
Yes, but that might be part and parcel, as I say, of a new planning application rather than a variation application standalone. It might be a new application to vary and reprovide.
A Section 73 application.
Well, it could be a 73, or it could be just simply a fresh planning application.
Yeah.
As I say, there's flexibility in how it could be done, so what's the value in putting us in a straitjacket?
Ms. Hunt.
So thank you. Yes, the first point is there are two ways in which this has now been suggested it could be done: a planning obligation or a new planning permission.
Yes.
Both of those go beyond what one would ordinarily understand by a scheme to be submitted and approved. So I'd also draw your attention to the PPG, which deals with when conditions can be used relating to land not in the applicant's control. And it makes the point they often fail tests of reasonableness and enforceability. It may be possible to achieve the result by a condition in a negative form, such as a gramping condition. So you have to be satisfied that this is properly enforceable. And in my submission, that would be achieved through the clarity that the council's wording offers, which is that this needs to be legally secured, legally enforceable. And in my submission, the use of the word scheme is simply insufficient to do that.
Okay, I understand. I mean, you're not. Neither of you are asking me to decide this now, are you? No, I'll just go away and consider it and put either version in, depending on what I feel. Yeah, okay, fine. So that's the Grampian condition, 23. As you say, Mr. Brownlee, those other four have been removed, so there were 33, and there should now be 30, shouldn't there?
Exactly right, sir. Yeah, 4 taken out, 2 ancient woodland, 2 sang, 1 added back in for the
Yeah.
reprovision of the parking. Exactly that.
And none of the others have changed, have they?
No other changes, and we worked together to formulate these conditions. The council did the heavy lifting, which we're grateful for in the first instance, so thank you. It's been a relatively straightforward exercise between us to agree the wording, which takes account of lighting at the reserved matter stage, etc., etc. The plans are clearly listed in the conditions as to what you're determining this application upon. So, yeah, nothing else to add from the appellant side, sir, unless you've got questions on the specifics of individual conditions.
No, I haven't got any issues. The only thing I'd say is have both sides double-checked that the plans are correct, because I'm not going to go through them and check them all.
So we wouldn't expect you to. That's a fair point. That the plans listed
Are the current plans?
conditions 4 and 5
Yeah.
reflect. So for your notes, the plans listed in 4 and 5 reflect the agreed position in CD 4.4, and you'll recall, sir, CD 4.4 was the updated Statement of Common Ground agreed pursuant to the agreement reached on highways. And in CD 4.4, the plans are listed in paragraph 2.15. So
Yeah.
that just reads across to conditions 4 and 5 effectively.
Yeah. Okay, well, I don't have any other comments about the conditions. There's nothing else the council wants to say, is there?
No, sir.
Okay, fine. Yeah. The only other thing I'd have to say, I'm not sure how they were sent to the office, how these documents were sent to the office, but just so I don't have to mess around with the tech, can you make sure, Mr. Brown, that the new list of conditions, the revised list, is sent in a Word document so I can just copy and paste it if I decide to allow the appeal? Okay,
That'll be done the next few seconds, sir.
okay, thank you. Right. Closings then. Do we want a short break before closings, or do we want a comfort break?
We just have to get ours off the printer, sir, so if we
Yeah,
could have
why
5 minutes.
don't we just have a, I don't know, 10-minute comfort break then?
Thank you.
So it's 20, well, I make it nearly 25 to, so start at 11. Okay, thanks.
We are. There was one matter I've just been reminded of yesterday. There was the supplementary submission where I think the appellant was going to have a look overnight and see whether it objected to it being
Oh, that's
put into the
right.
inquiry. Do you remember?
Yes, I
'cause
knew
we
I
will
forget
have
to
to.
mention this. Yes.
Yeah, we'll have to update. I can't remember who it came
It
from.
was from Uckfield
Town Council. Yeah,
although Miss Love did speak for Uckfield Town Council.
yeah.
So, Mr. Tabachnik, have you seen that? You've read that, have you?
Yes, sir. We've looked at it, and we do object to it. It's really too late in the process for this sort of material to come in. I think really the position is that third parties have had ample opportunity to submit during the appeal process and various dates for them to make written submissions, and they all took that up. A day or a morning set aside on day one for third parties to come along. Obviously, we accept that some people are on holiday, and so those people were accommodated yesterday morning. But otherwise, the position is by the time you get to the end of day 3 or the beginning of the last day of an inquiry, that either it's all been said and you're simply given further repetition, which is unnecessary, or else it's new, in which case it's not fair. And too late for us to be expected to respond after all my witnesses have come and gone and given evidence. And this is a mixture of repetition and some new material. And so I object to it because the old stuff has already been said and the new stuff shouldn't be said this late. Thank you, sir.
Is there anything you want to say about that?
So it's not part of my case. It's
No,
just-
no. Well, I'm going to reject it then. I'm not going to have it. Just as I've rejected various other people's late submissions via the case officer. Yeah, it's far too late. I agree. Yes, so over to you, Ms. Hutton.
Thank you, sir. I just asked Mr. Redmond to circulate the written copy.
Thank you very much.
So the issues between the council and the appellant are narrow. The sole matter in dispute between the main parties is whether the public benefits of the proposal outweigh the harm to the unique Grade 2 listed house, which lies at the heart of the appeal site. Mr. Brown accepted that if they do not, there would be a strong reason for refusal and permission should be refused. In 2023, the inspector dismissed a previous appeal on several grounds, one of which was that the public benefits associated with the delivery of 290 dwellings, both market and affordable, a strategic sang, open space and other elements were not sufficient to outweigh the heritage harm. The revised scheme now proposes 190 dwellings, a smaller sang, a reduced open space provision. The central question, therefore, is whether these changes, alongside the clear reduction in public benefits, are now sufficient to outweigh the heritage harm which endures and has not been significantly reduced. Turning to the benefits. In 2023, the inspector summarised the benefits of the scheme as follows. Economic benefits derived from the provision of 290 homes, of which 35% would be affordable housing and 5% self-build homes, in an area where there is agreed and long-standing shortfall of housing land supply, the current figure being 3.92 years. These homes would drive economic growth in the area through the associated expenditure and job creation that new housing provides. Appropriate conditions also mean this development could come forward relatively quickly. The sang mitigation was considered neutral in planning terms, though some public benefit was identified from its accessibility to other visitors. Biodiversity net gain of 40%, along with new tree planting, provision of sustainable homes, recreational space and landscaping. Taken together, the inspector concluded these benefits attracted substantial weight. The categories of benefits in the current appeal scheme remain essentially the same. The provision of housing continues to represent a significant, or very high, as Mr. Redmond described it, benefit, albeit the current scheme delivers 100 fewer homes than in 2023. The council still cannot demonstrate a 5-year housing land supply, and that position has worsened since the previous appeal. This is unsurprising, given the increased housing targets under the revised standard method introduced by the current government. The delivery of 35% affordable housing continues to carry significant weight, particularly in the context of the continuing and pressing need for such provision.
Mr Redmond was clear that the reason why the delivery of 35% affordable housing attracts significant weight is the clear need, which has increased since the last inquiry. The inclusion of self-build and custom-built homes also attracts positive weight. It's correct that the Council has been unable to demonstrate a 5-year supply of housing land for approximately 9 years. Mr Redmond confirmed that there was a housing delivery crisis in the district. He explained that the consequences of this shortfall include rising house prices and loss of associated social and economic benefits. He also confirmed that no weight should be given to the emerging local plan. Nonetheless, as Mr Redmond confirmed, this is an authority which is continuing to grant planning permissions, notwithstanding the constraints of the district. It's not an authority which seeks to unnecessarily restrict development, and that is evident from the Council's approach to this appeal. Mr Redmond confirmed that he would not object to a substantial number of dwellings being provided on the appeal site, but it is the quantum which results in unacceptable heritage harm, i.e. harm which is not outweighed by the public benefits. A reduced scheme would significantly reduce heritage harm to the Oast House by avoiding housing to the west of the listed asset, see below. This would be likely to tip the public balance and the benefits balance in the appellant's favour. Insofar as the appellant seeks to argue that these houses would come forward within 5 years, that is wholly unsubstantiated. As Mr Redmond explained, the need for reserved matters approvals and discharge of conditions would likely delay delivery beyond the 5-year period. As is well known and was addressed by the evidence of Ms Smith to the inquiry, Southern Water are insisting on the imposition of a Grampian condition on the occupation of new development prior to necessary upgrades to their infrastructure to accommodate additional foul flows from development. Southern Water has not commented on this appeal scheme, but its previous representation is at Appendix G of CD 1.26. That letter identifies a risk of foul flooding and confirms that network reinforcement may be necessary and the delivery of such reinforcement could take at least 24 months or potentially longer. Despite the letter being written in 2021, those works have not taken place. Mr Brown confirmed that he had not had any discussions with Southern Water. It's therefore entirely unclear how long it will take for the upgrade works to occur or even whether they have funding. The Council is unaware of any solution to address this issue. In any event, and as set out above, whether or not these houses can be delivered and occupied within 5 years, the Council accepts that significant or very high weight should be given to them. The economic benefits arriving from housing delivery remain relevant, fortunately reduced to reflect the smaller scheme, approximately 2/3 of those identified in 2023. They attract moderate weight. The delivery of BNG above 10% also attracts moderate weight, as agreed by Mr Redmond and Mr Brown. While the sang and recreational open space continues to function primarily as mitigation, the additional public accessibility continues to attract some weight, but this is obviously limited. The amount of open space is less than half that which was provided in 2023, and it's clearly not credible for it now to attract more weight than it was given by the inspector in that decision. The Council accepts that the homes would be located in a sustainable location. However, it's difficult to see how this can be considered a weighty benefit in its own right. Contributions towards bus services and highway works, as confirmed in the SIL compliance schedule, are mitigation necessary to make the development acceptable in planning terms. The appellant has asserted that the scheme would deliver highway safety benefits. However, these were not agreed in the Statement of Common Ground with the local highway authority. During the Highways Round Table, it became clear the local highway authority did not support the appellant's position. Ms Campbell explained that although the visibility splay at the existing farm access is substandard and the entrance is partly single carriageway, it has functioned safely for many years. Although she acknowledged that occupiers numbers 18 and 19 Burden Eye Hill might feel more confident using the new access, in her professional opinion, it would not be materially safer. Ms Campbell confirmed that with regards to speeds on Burden Eye Hill, whilst the limit is 60 miles per hour, actual speeds are around 40 miles per hour, and she did not agree that the scheme would make the road materially safer as a result of the reduction of speeds. As Mr Brown agreed, the views of the local highway authority should be given significant weight. The appellant's claims of highway safety benefits are therefore overstated. In reality, the highway works are simply what is required to support development of this scale in this location. In summary, while the appellant has overstated some of the benefits, the Council accepts that the scheme would still deliver substantial benefits. However, these are inevitably diminished in comparison to the 2023 scheme, reflecting the reduced scale of development, and it's against this lesser level of benefits that the enduring heritage harm must now be weighed. I turn now to heritage harm. Since taking office, the government has amended the NPPF. and is currently pursuing further reforms through the Planning and Infrastructure Bill. However, it's notable that the government has neither amended nor proposed to amend the statutory duty under Section 66 of the Listed Buildings and Conservation Areas Act, nor has it altered the relevant heritage paragraphs in the NPPF. Had the government wished to water down protection to heritage assets, it could have done so. Accordingly, the legislative and policy framework aimed at protecting heritage assets remains unchanged from that which applied in 2023. It is well established in law that the harm to the setting of a heritage asset must be given considerable importance and weight. In the case of South Lakeland, Lord Bridge, addressing harm to conservation areas, put it this way. So having discussed the statutory provision relating to conservation areas, I'll read out the underlined text. If any proposed development would conflict with that objective, there will be a strong presumption against the grant of planning permission, though no doubt in exceptional cases the presumption may be overridden in favour of development which is desirable on the ground of some other public interest. In Barnwell Manor, the Court of Appeal reaffirmed this approach, confirming that a strong presumption exists against the grant of planning permission where harm arises to the setting of a listed building. It's within this established legal and policy context that the heritage balance required by paragraph 215 of the NPPF must be applied. The statutory duty reflects the fundamental principle that heritage assets are irreplaceable. Where significance is lost, such as through permanent inappropriate development within a heritage asset setting, it cannot be recovered. The NPPF confirms that great weight should be given to the conservation of heritage assets, and the greater the importance of the asset, the greater the weight that should be accorded. Notably, the NPPF does not define importance solely by reference to the level of designation. As Dr. Mealy's evidence confirms, the Oast House is unique and undoubtedly of exceptional importance. It was described as a local landmark by the previous inspector. This is by no means a run-of-the-mill heritage asset. Further, any harm to the loss of or significance of a designated heritage asset, including that resulting from development within its setting, requires clear and convincing justification. Paragraph 213 of the NPPF. Turning to the previous decision on heritage matters. It's notable that the appellant has not, at this inquiry, sought to argue that Inspector Butcher's previous decision was flawed in any way. Indeed, during the Heritage Roundtable session, Dr. Mealy confirmed he agreed with the inspector's findings of harm and referred to the decision as a baseline. In response to a question from you, sir, he further confirmed his agreement with the previous findings on the importance of the Oast House's setting. The appellant is not inviting this inquiry to revisit earlier conclusions regarding the significance of the asset, the contribution its setting makes to that significance, or the identified heritage harm arising from the previous scheme. Nor has it argued that Inspector Butcher struck the public benefits balance wrongly. Rather, the appellant seeks to demonstrate that revisions to the scheme have sufficiently addressed the inspector's findings. The key question, therefore, is whether the amendments to the appeal scheme have sufficiently reduced the harm so as to tip the public benefits balance in the appellant's favour. The Council submits that the answer to that question must clearly be, they have not. The previous inspector identified how the setting contributes to the Oast House's significance in the following terms. The setting to the Oast House contributes to its significance insofar as its historic use for drying hops and functional relationship with the surrounding fields which grew the hops can still be appreciated today. These fields remain open, undeveloped, and in use as pasture. Consequently, they enable the Oast House to be appreciated in broadly its historic rural scene. These fields also provide for a qualitative understanding of the significance of the Oast House derived from its setting, as they provide a degree of quiet and tranquility which you would reasonably associate with such a rural historic scene. Furthermore, the lack of development in these fields, along with its elevated position above the town, gives it a local landmark quality. And the inspector went on to conclude that the proposed development of 290 houses, access roads and attenuation basin within the setting of the Oast House, consequently, any remaining ability to appreciate the significance of the Oast House in its historic rural setting would largely be lost. The level of development proposed would also visually compete with and distract from its local landmark quality. Furthermore, the relatively quiet and tranquil character of the setting of the Oast House would be significantly diminished by the large-scale residential development proposed. The elements suggest that an area or areas of open land could be designed in the final layout of the development, as shown on the illustrative site layout, in order to provide an element of the rural setting of the Oast House. However, given the scale of development proposed, any such land would be relatively modest in size, flanked by development, likely landscaped, and would not provide any meaningful historic views of the Oast House I've been made aware of. This would therefore reduce the harm I've found to the setting by a very minimal degree, as its setting, as currently experienced, is far wider, more extensive and rural in character. An information board could also be provided as part of the development, providing interpretation as to the significance of the Oast House in terms of its technical rarity, and this would better reveal its significance. However, it would not minimise the specific harm to setting that I have identified. As discussed in more detail below, the impacts identified by the previous inspector continue to arise. While the reduction in the number of dwellings has resulted in a larger area of open land to the west of the Oast House, this space would still be flanked by built development subject to landscaping. It would not be rural, but suburban. The historic agricultural setting would be completely lost. The development would continue to compete with and distract from the landmark quality of the Oast House, and the quiet, tranquil, undeveloped character of its setting would still be significantly diminished. So turning to the significance of the Oast House. The Oast House is a Grade 2 listed building, but its significance cannot be reduced merely to its designation. The appellant's own evidence describes it as unique. As Ms. Tucker explains, the fact that the Oast flue system and its associated furnace and drying floor remain intact and largely unaltered within the square Oast kiln, this building is a rare example that has not been lost through conversion. In addition, the original stowage barn survives, and the presence of a second stowage barn reflects the historical importance of the hop industry locally and beyond the 19th century. Applying Historic England's Farmstead Assessment Framework, Ms. Tucker identifies that the Oast House and associated group of traditional farm buildings contribute to local distinctiveness because A, the core of the historic farmyard retains overall form of a traditional loose courtyard, with three sides formed by agricultural buildings and a smaller secondary yard. The farmhouse lies apart to the south, clearly visible in views from the west, the axis and the surrounding fields. B, the courtyard buildings, Oast House and farmhouse, all appear on the tithe map, and the key OS maps up to 1900 are typical in their overall form. C, the use of local stone in the Oast House adds to its local character. And D, the surrounding fields, historically and functionally linked to the farmstead, retain their general form. And Ms. Tucker therefore summarises the significance of the Oast House as follows. Birdernigh Oast has special architectural and historic interest as a Grade 2 listed building. The significance and special interest of the building lies in its origin as a 19th century agricultural building of a specialist type associated with the Weald and hop industry, with legible building typologies. Its historic character, fabric and architectural detailing, exhibiting technological advancements with the application of local materials and with historic associations to the 18th century farm at Birdernigh. The key attributes of the heritage asset itself are its rare survival as an unconverted Oast kiln and the significance as a technological advance in hop drying and context within a farmstead group. Turning then to the contribution of setting to the Oast House's significance. Ms. Tucker undertakes a detailed analysis of how setting and views contribute to or allow appreciation of the Oast House significance, applying Step 2 of Historic England's Good Practice Advice Note 3. In summary, the physical surroundings make a positive and important contribution to the significance of the asset due to the functional relationship and direct spatial and visual relationships. The appeal site includes land historically associated with the Oast House. It's highly likely that this land was used for growing hops. The tithe map of 1840 confirms this historic connection. While field boundaries have evolved, as Ms. Tucker stated, is the nature of farming and typical in agricultural landscapes, the broader field system established by 1875 remains intact today. The setting contributes positively to the asset's significance in its own right. There remains a clear visual and historic relationship between the Oast House and its surrounding fields, including an area marked as hop garden on the tithe map. This connection was evident during and reflects the building's former agricultural function. The Oast House continues to be visually associated with the former 19th century farm buildings to its south, preserving the historic form of the farmstead. Though parts of the farmstead are now in commercial use, with some modern farm buildings are present, these changes are not atypical. They do not diminish the Oast House's heritage value. The Oast House and former historic farm buildings remain clearly identifiable on the western edge of the farmstead. The Oast House is locally distinctive and, as acknowledged by 2023 inspector, acts as a landmark. Oast houses are strongly characteristic of the Weald landscape. As Ms Tucker notes, sitting in the centre of the farmstead, with which it still has legibility, the agricultural character and uses of the surrounding land with which the farmstead has had a historic functional association also communicates and contextualises the significance of the Oast House. In longer range views, the Oast House sits on a ridge as a landmark within its rural context. The surrounding open fields reinforce the appreciation of the traditional isolated nature of the farmstead, located beyond the built edge of Uckfield. Views from the town's edge are particularly significant in appreciating this relationship. The approach to the Oast House from Framfield Road is also notable. Although the access was altered as part of the 1986 Planning Permission for conversion of the historic farm buildings, the Oast House is still prominent and easily appreciable when arriving at the site and is the first traditional building seen from the access. Within the site, it is experienced in conjunction with the former 19th century agricultural buildings. The rural character of the access is retained and appreciated. The farmstead is appreciated as an isolated group within its rural surroundings. From the Oast House itself, there are expansive views over the surrounding rural landscape, views which form part of the building's historic setting and were evident on the site visit. On topography, Dr. Mealy acknowledged that, upon instruction, his advice was that there should be no development on the plateau where the Oast House sits. While the plateau is visible in Plate 2 of Ms Tucker's evidence, she notes that its prominence should not be overestimated. Views out from the Oast House show a defined edge to the plateau, whereas views up to the Oast House from the west reveal a more gradual slope. In any event, as addressed below, the appellant has not avoided building upon higher ground. Turning to the impact of the proposals. The appeal scheme reduces the number of dwellings from the 2023 proposal. While this results in a modest reduction in overall harm, the harm remains considerable and weighty. Ms Tucker identifies 5 elements of particular concern which are addressed in turn below. However, it's first necessary to address the pre-application discussions between the Council and the appellant. As explained during the Heritage Roundtable, Ms Tucker was unequivocal that she made it explicit to the appellant that housing to the northwest and southwest of the Oast House would not be acceptable. Ms Tucker's evidence was corroborated by that of Ms Turner, the planning officer, whose opinion was relayed to the inquiry by Mr Redman. The appellant has referred to the term easement in the Council's pre-application letter, referred to by Mr Brown. However, the officer who authored that letter is no longer with the Council, and it remains unclear what was meant by that term. As Mr Brown confirmed, none of the pre-application documents referred to the term easement at all. It's notable that though Mr Brown was at the meeting, he did not give his own recollection of the meeting, but relied solely upon the letter. In any event, as Mr Brown also agreed, whatever may have been said at the pre-application meeting on the basis of different proposals, and there is clearly a dispute, the key issue for this inquiry is the impact of the scheme, which is now before you, sir. So starting with the island of housing to the northwest. The illustrative master plan includes 10 houses to the northwest of the Oast House. While there is currently some sporadic development parallel to the B2102, the proposed housing here would be of greater density and would not integrate with the low-grain sporadic development. The houses would be closer to the Oast House, clearly visible in views from it, and require access roads and associated infrastructure. At the Heritage Roundtable, Ms Tucker explained that the sloping topography would result in this part of the development appearing dominant in views into the site from the west, particularly when approaching the site via the footpath. Though there is some existing screening and additional planting is proposed, GPA 3 cautions against over-reliance on screening and that it ought never to be regarded as a substitute for well-designed developments within the setting of heritage assets. The introduction of development into the rural setting itself is the harm. Screening does not remove the loss of rural context and the negative impact of the proposed development. The appellant also claims these houses could be designed to reflect hopper huts. Dr. Mealy during the round table stated this phrase did not appear in his proof of evidence. However, paragraph 6.9 of his proof does refer to the design being influenced by hopper huts. Ms Tucker introduced some images of genuine hopper huts, small utilitarian structures used for seasonal labour, to demonstrate that modern houses would bear little resemblance to such buildings. In reality, a rural vernacular would not meaningfully mitigate the harm. Turning to houses to the southwest. The placement of dwellings on this higher ground appears to directly contradict Dr. Mealy's initial advice that development should be avoided on the plateau. He acknowledged that development on the plateau would inevitably encroach on the ability to appreciate the interaction with the landscape, and that is precisely the effect of this part of the scheme. The heritage statement wrongly suggested these houses would be screened by farm buildings. The site visit confirmed that they would be visible from the Oast House at ground level and from the external stairs. These views, historically enjoyed, presently show clear separation from the edge of Uckfield, with the fields remaining in pastoral in character. Proposed housing would be situated within fields historically cultivated in association with the farm buildings, including the Oast, irreversibly altering the Oast House's rural context into a suburban one, thereby diminishing both its significance and our ability to appreciate that significance. Furthermore, this housing would be prominently visible in views towards the Oast House, particularly from the west, e.g. from the hospital, adjacent residential areas and Framfield Road, where the asset is currently read against the legible backdrop of the farmstead. It would significantly affect the appreciation of the Oast House's visual and functional association with its open rural landscape. In re-examination, Mr. Brown was invited to state that the buildings would not be visible from the west. The Council considers this as clearly incorrect, as would have been evident from the site visit. Dr. Mealy noted that Uckfield has gradually expanded towards the Oast House. As Ms. Tucker explained, this only increases the importance of protecting the remaining undeveloped rural elements of the setting, as supported by GPA 3. I've given you the references there. During the round table, so you asked Dr. Mealy whether he advised against westward development. He said that he had not, citing complexity of topography, the need for further design work and the issue of additional constraints. However, he did not suggest that such development would be appropriate in this sensitive area, and he later acknowledged its sensitivity. Dr. Mealy's claim that development would integrate with the topography is unfounded. As Ms. Tucker confirmed, and was also viewed at the site visits, both from the stairs to the Oast House and at ground level to the rear of the Oast House, the housing would extend onto the higher plateau of ground, projecting westward and disrupting the open rural condition of the land that Dr. Mealy himself acknowledged was integral to the Oast House's setting, the open space. Although the land west of the Oast House is shown as open space, there would be clear and material change in its character, from rural pasture to managed parkland amenity space. It would include lighting, engineered 3-metre wide pedestrian and cycle routes, seating, bins and signage. Such infrastructure, coupled with regular public use, would substantially diminish the tranquil and rural character of this part of the setting. Moreover, the land would be flanked by housing on both the northwest and southwest, a feature previously identified in the 2023 Inspector's decision as particularly harmful. It is true that users of the open space would experience views back towards the Oast House. However, as noted in the 2023 decision, there's no suggestion these are historic views. Further, these views would now be across a managed landscape, forming part of a housing development, no longer across its historic rural setting. As Ms. Tucker explained during the round table, GPA 3 makes clear that the contribution of setting to significance does not depend on public access or visitor numbers. Such an approach undervalues qualities like tranquility, which are essential to the asset setting and significance. Access to the site. Although the original farm access has been modified at its northern end, the route still represents the historic approach to the farmstead. It traverses open paddock land and retains its rural character. The landmark Oast House is visible on approach, and the isolated quality of the farmstead is still appreciable. The appeal scheme proposes heavily engineered new access, including 2 roundabouts and significant level changes. This would introduce lighting, noise, vehicular movements and urbanising features. It's unclear whether the cowl of the Oast House would remain visible, but in any event the rural character of this part of the setting would be eroded and the experience of arriving at the historic farmstead diminished. Tranquility. Despite the conversion of some farm buildings, the Oast House's setting remains tranquil, and this was recognised by the 2023 inspector. Ms. Tucker explained that the area retains dark skies with little external lighting from nearby buildings. The introduction of 190 houses with associated lighting, vehicular movements, domestic activity, and the opening of a sign to the public would fundamentally disrupt that tranquility. While the Oast House itself would not be lit, the surrounding area would be, therefore permanently disrupting the dark skies that form part of its historic and experiential setting. Turning to heritage benefits. The appellant points to some benefits, the installation of an interpretation board, the removal of car parking from the Oast House's immediate setting, and the opening up of public views. The interpretation board was attributed minor weight in 2023, and there's no reason to reach a different conclusion now. Ms Tucker accepts that the removal of car parking to the west of the Oast House is a benefit. However, she noted that the immediate setting of the Oast House may historically have included activity and possibly parking. Moreover, this benefit, assuming it's deliverable, does not significantly reduce the overall harm and certainly does not outweigh the permanent loss of the Oast House's historic rural surroundings. The scheme would result in more members of the public having opportunities to view and appreciate the Oast House. However, as advised by GPA 3, the contribution of setting to significance does not depend on public rights or ability to access it. Significance is not dependent on the numbers of people visiting it. Again, together with the other benefits, does not come close to outweighing the harm set out above. Turning to the appellant's position. The council understood from the Heritage Roundtable that Dr. Mealy's evidence was that he'd performed an internal heritage balance as part of his evidence. Initially in cross-examination, Mr. Brown confirmed this was the case. However, he was interrupted by Mr. Tabachnik, KC, who informed the inquiry that in fact Dr. Mealy had not performed any internal heritage balance. It's worth reflecting on that point. It's simply not credible for Dr. Mealy or the appellant to assert that once the significance of the Oast House is understood, and once the contribution of its setting, which includes the entirety of the appeal site, to that significance is also understood, that the proposal would result in no harm. The scheme would result in the complete loss of the agricultural pastoral elements of the Oast House's setting, the development of fields which are functionally connected to the asset, the introduction of substantial built form and views both to and from the Oast House, including development on rising and higher ground, the flanking of the open space with development, disruption of tranquility noted in 2023, and which inevitably comes with large housing development, and extensive highway works of a scale and character incompatible with the rural setting. In the Council's view, the position taken by the appellant is simply not credible and not serious and should be rejected accordingly. The careful and considered assessment of Ms. Tucker should be preferred. Turning to unnecessary harm. As set out during the pre-application discussions and now evident from the appeal scheme, the placement of housing westward of the Oast House is particularly harmful. Mr. Brown accepted that there is a national legislative and policy objective to minimise harm to heritage assets, and that any such harm requires clear and convincing justification. Based on the current illustrative site layout plan, removing the two most harmful areas would reduce the total number of homes by around 36. However, it may possibly be fewer if the eastern part of the site will be reconfigured with density increased. As explained by Ms. Tucker and Mr. Redmond in their proofs, a relatively small proportion of the scheme is responsible for a disproportionate level of harm. This was explained in their proofs of evidence. The key point is this: where parts of the proposal are disproportionately harmful, causing clear and weighty harm, but the large parts of the benefits could be delivered by a reduced or alternative scheme, which is significantly less harmful, then that is a weighty consideration in the heritage balance. Although Mr. Brown did not agree with the Council's assessment of harm, he accepted that should you, sir, agree with the Council's position, then this is a factor which could be taken into account when weighing the public benefits against the harm. In re-examination, Mr. Brown was invited to state that if the public benefits test was passed, there would be no need to separately consider whether there is clear and convincing justification for the harm. First, sir, that misses the point. As Mr. Brown accepted, the consideration of whether a large part of the benefits could be delivered by a reduced scheme is part of the public benefits balance. Second, and in any event, the NPPF is clear that all harm requires clear and convincing justification, and that is something which obviously needs to be explicitly considered by the decision maker. And so an example of this situation was the recent solar farm appeal decision in Ashford in Kent. There, the inspector found that there would be harm, low to medium, to a few heritage assets. The harm was temporary for 40 years, and the public benefits were substantial indeed. However, the inspector found that the substantial benefits did not outweigh the low to moderate heritage harm. And so he explained that the central reason behind that conclusion is the fact that a good deal of the benefits offered by the scheme could be provided without any harmful impact at all on the setting and thereby significance of two very important designated heritage assets, or for that matter, any others. The inspector went on to find carried out this balancing exercise on the basis of the scheme as it's presented and formed my conclusions accordingly. However, having regard to the way the matter was explored in inquiry, I'm firmly of the view that a better design scheme, using the appeal site in the way that avoided these impacts, could bring forward most, if not all, the same benefits. And paragraph 213 of the framework says that any harm to or loss of significance of designated heritage asset should require clear and convincing justification. On the basis of the foregoing, I'm not persuaded this requirement has been met. The appellant has sought to distinguish Ashford on the basis that it dealt with higher order assets. It's a hopeless suggestion given the fact the MPPF is clear that any harm to significance requires clear and convincing justification. The appellant also stated that the assets in Ashford had not been appreciated by the appellant at that appeal. However, that inquiry heard heritage evidence on behalf of the appellant, so it's entirely unclear how this is relevant. Finally, and in any event, Mr. Brown accepted that the principle which applied in Ashford was capable of being a material consideration in the public benefits balance, and so there's little to be gained by seeking to distinguish the decision on the facts. Here, a large-scale residential scheme could be delivered without the particularly harmful westward development. That harm, unlike in Ashford, would be permanent and irreversible. Mr. Brown confirmed that the weights that he gave to the benefits of this appeal scheme would not change if the scheme was for 36 fewer houses. Thus, it's the case that though there would be fewer houses, a good deal of the same benefits would come forward. The disproportionate and avoidable nature of the harm from building westwards of the Oast House weighs heavily in the heritage balance and supports the Council's view that the public benefits do not outweigh the harm. Most of the benefits could be delivered by a slightly reduced scheme that avoids these sources of harm. In short, there's no clear and convincing justification for the overdevelopment of this site by circa 36 houses, which would lead to the disproportionate level of harm. Mr. Redmond confirmed in his evidence that without those houses, the public benefits balance would tip in favour of the scheme being allowed. This is a weighty material consideration in the balance. There's a clear way in which a good deal of permanent and irreversible harm to this asset can be avoided, and that is through a scheme with slightly reduced numbers. So turning to the public benefit balance. Ms. Tucker has applied an internal heritage balance and concluded that proposals were called moderate level of harm on a scale of low, moderate and high. This reflects a modest reduction from 2023. However, moderate harm is not a moderate planning objection, and as confirmed in Lambeth, such harm must attract considerable importance and weight, triggering a strong presumption against granting planning permission. Set out above, the scheme would deliver public benefits, largely similar in nature to those previously identified in 2023, albeit reduced in scale. They are insufficient to outweigh the heritage harm. In addition, there's clear potential for a slightly smaller scheme to come forward on the appeal site without housing to the west of the Oast House, which would cause significantly less harm and deliver the majority of the benefits. There is therefore a strong reason for refusing planning permission. The presumption in favour of sustainable development does not apply. Other decisions. The appellant has included other examples of cases where public benefits were held to outweigh harm, including Buxted and land north of Eastbourne. These involve different assets and different development proposals. The MPPF requires decision makers to assess the significance of each asset individually, the contribution of the asset setting to its significance, the impact of any given scheme, and to reach an individual judgment as to whether the public benefits outweigh the harm. Consequently, little weight can be given to a compare and contrast exercise involving unrelated cases concerning different sites and developments affecting different assets, decided by different people using individual judgment. As Mr. Redmond noted, none of the decisions cited involve schemes where the vast majority of benefits could be delivered with materially less harm through minor amendments. Most importantly, the 2023 appeal decision on this very site remains of central relevance, and the appellant has not disputed those findings. The only question is whether the scheme now, though the changes made, now tip the public benefits balance in their favour. They do not. Comparison with other cases does not assist in determining this appeal. Finally, planning balance and conclusion. The parties are agreed there is a breach of the development plan as a result of the breach of locational policies. There is also a breach of EN1, EN7, SPO2 and WCS 14 as a result of the heritage harm from the scheme. There is no basis for according less weight to SPO2, as Mr. Brown sought to do. That position is contrary to the position of the Court of Appeal and City and Country, where similar policies were found not to be inconsistent with the MPPF. The MPPF is clearly a weighty material consideration. Here, paragraph 11D applies as policies which are most important for determining the application are out of date due to the council being unable to demonstrate a 5-year supply of housing land. The application of policies in the NPPF provides a strong reason for refusing development proposed. In short, the harm to the Oast House is not outweighed by public benefits of the scheme. Additionally, a reduction in dwelling numbers would materially reduce the harm to the Oast House, and this is a material consideration which weighs heavily against the scheme. There is simply no clear and convincing justification for the level of harm caused by the appeal scheme. As stated above, sir, the key issue in this appeal is whether the development proposal has been sufficiently amended so as to tip the heritage balance in the appellant's favour. In short, it has not, and sir, the council invites you to refuse permission.
Thank you, Ms Hutton. Okay, Mr Tabachnik. And I presume if you have any comments to make on the LPA's closings, then you're going to say them orally, and I'll just make a note of them, yes?
Yes, I'll make them as we go along.
Yeah, as we go along, yeah. Thank you.
So, as I said in opening, and as the inquiry process has demonstrated, the appeal scheme has been carefully thought through to address the reasons for which the 2023 scheme was dismissed. The appeal scheme will bring substantial and weighty planning benefits in a location which it is agreed with the council and the county highways, consistent with the 2023 findings, is locationally sustainable. The appeal scheme is much needed in this district. A high-quality scheme in an attractive setting, surrounded by woodland and open land, is eminently achievable. Heritage impacts first. The council's case on alleged heritage impacts is seriously overstated. It focuses on making points about changes to the peripheral setting of the Oast, but fails to articulate with any coherence how these changes are said adversely to affect an ability to appreciate the significance of the Oast. It ignores the 3.5 hectare open space to the west of the Oast, which provides substantial separations, 110 metres to 130 metres, so far as the closest proposed homes to the south and north respectively are concerned, as well as allowing a continuing opportunity to view the Oast in an open setting. Equally, the council diminishes the value of the creation of new views for proposed residents of the Oast and Farmstead group in a generous retained open setting, some of which will be extremely pleasing, notably the views on arrival in the northwest corner and views towards the Oast while walking across or picnicking on the POS to its west. This, along with the removal of the unsightly car parking and power lines in the immediate setting of the Oast, are clear enhancements which are to be recognised as such in accordance with GPA 3 paragraph 38, and to which considerable weight should be given per 212 and 219 of the framework. Most disappointing of all, the council ignores the fact that the pre-application advice which it gave in June last year has been fully adhered to, only for the council unreasonably to change the goalposts. Mr. Redmond's evidence, denying vociferously that the easement, it's a quote from the letter, obviously the word easement, was the power line easement, but offering no alternative explanation as to what was being referred to, defies explanation and is the mark of a council which has lost the power of rational thought in relation to this appeal. Picking up on some of the themes set out in the above paragraph. Firstly, on analysis, the council's approach only pays lip service to step 3 in the GPA 3 analysis. That's the one about relating any setting changes to a reduction in significance or the ability to appreciate significance. It's really the key step in the GPA 3 analysis. The setting changes that the council draws attention to housing 110 plus metres away, new access arrangements, footway, cycleway and sud features that will barely be noticeable from the vicinity of the Oast do not diminish in any way the ability to appreciate the Oast in a retained open setting, nor does the council even attempt to explain why they do. And so I pause there. I'll come back to some of these points later in this. I pause there to note that there are a large number of assertions in the council's closings about what you will and won't see from the Oast. You can go through and mark them up as you see fit. Obviously, you've done the site visit. We regard many of those assertions as simply factually inaccurate, not just a wrong assessment, but factually inaccurate and clearly contrary to the position that you will have observed. So I ask you to exercise very considerable caution about those assertions in the council's closing submissions and indeed throughout their evidence. 3.2. Fundamentally, the council's evidence to the inquiry has failed to appreciate how the retained 3.5 hectare open area west of the Oast preserves its setting, allowing a continuing understanding of the connection between the farm group and a wide swathe of retained open land. As concluded by Dr. Mealy, one of the country's foremost heritage experts, in his proof, I conclude that the retained land preserves a sufficiently large expanse of open land to maintain an appreciation of the present context reflecting an earlier rural one. And so you'll recall at the Heritage Round Table, you yourself put to Dr. Mealy, so in effect your point is the Oast currently is perceived within an open setting and the scheme by and large retains that. And he said that is exactly my point. And that is the point, sir, and that is why there is no harm to the significance of the Oast, despite the changes which are introduced within its wider setting. And going back to 3.2, this is the principal basis on which Dr. Mealy concludes that the significance of the Oast is at least preserved and in consequence no heritage harm arises. And so we invite you to agree with his analysis. The council's historical analysis, which was, as Ms Tucker admitted at the round table, based in part on anecdotal evidence, has not established that any field other than field 1451 was formerly used for hop growing. Otherwise, the council's case is conjecture unsupported by proof. The Oast was part of a 70 hectare holding, and it is not otherwise clear where hops were once grown. Further, field 1451 is somewhat remote from the Oast, and the relevant map shows it was separated by a wooded coppice. None of the field divisions and boundaries from the relevant tithe map survive, nor is there currently, 60 years after the Oast fell into disuse, any evident sign of any particular field, any particular land, field 1451 or otherwise, having been used for hop growing. As Dr. Mealy explained to the inquiry, those matters are ascertainable solely by reference to the historical record, which is obviously unaffected by the appeal scheme. Again, in the words of Dr. Mealy, paragraph 17 of his summary, I consider that the amount of land that is left open in the present proposals is sufficient to preserve the setting of the listed building, enabling one to appreciate its historic setting. The housing has been positioned to maintain clear views across that land from the Oast. Likewise, it will continue to be appreciated across open land from those limited positions to the west from where the historic building's distinctive cow can be appreciated. The location of the proposed housing is distant from the Oast and peripheral to its setting. The proposed housing does not compete with the Oast in any viewpoint. It does not block or intrude into views of or up to the Oast from the west or anywhere else. None of the housing can be seen in the immediate vicinity of the Oast looking out at ground floor level. That's one clear inaccuracy in the council's closing submissions, sir. Now, neither the housing to the southwest nor to the north can be seen when you're in the immediate vicinity of the Oast at ground floor level. One has to walk about 20 to 30 metres across the car park from the Oast, and with the Oast behind one to do so. It's impossible to understand how such a relationship results in harm to the significance of the listed building. It's not reasonable, though it is unfortunately so, that the Council's case at this inquiry fundamentally contradicts its pre-app advice from June last year. The letter at Miss Tucker's Appendix B was commenting on the 235 house proposal at Mealy page 13, or I think you've also got it at SB 6.1, sir. The Council requested 3 changes. Firstly, taking the southwest housing back to the easement. Secondly, removing the road across the land to the west. And thirdly, removing the northwest corner of housing. All these requests are complied with, but the Council has unreasonably changed the goalposts. Specifically, A, the request that the southern portion be shrunk back to the easement was a request to remove proposed housing west of the power line easement, as had been incorporated. There is no other easement that the Council could have been referring to than the power line easement, which had been shown on a constraints plan available to planning officers in attendance at the meeting, including one officer, Miss Turner, who had been the case officer for the 2023 appeal scheme. And with respect, sir, it's really very surprising and disappointing that the Council's closings purport to place some reliance on Miss Turner's position. Miss Turner's never produced a statement in relation to that meeting. We haven't got anything direct from her. We haven't got an email. We haven't got a witness statement. We haven't got a proof. We've not got a single jot of paper. We have a hearsay report from Mr. Redman. It's hard to imagine lower quality evidence being presented, and yet it was presented and indeed relied on heavily in the Council's closing submissions. You have to wonder why. Why does one put forward and rely heavily on evidence of such poor quality? And the answer is because of the obvious difficulties that the Council now recognises it's in running a case at this appeal that's fundamentally contradicted by what it said in its pre-app letter. I'm not obviously reopening the question of costs applications. That's done, but this is not a reasonable way to proceed. Reverting to my closings just after the brackets, about 6 or 7 lines down. Mr. Redman's absurd evidence denying that the easement was the power line easement while failing to identify any even remotely credible alternative candidate has already been commented on. Further, it's always necessary to be extremely cautious about witnesses in the position of Miss Tucker reconstructing what they think they may have said in a meeting nearly 14 months ago. Claimed memories of such matters without supporting written evidence, that's obviously contemporaneous written evidence I'm referring to, are notoriously unreliable. These matters have been commented on in numerous High Court judgments, which emphasise the importance of contemporaneous written material when such a question arises. To be clear, there's no suggestion of deliberate lying, but the contemporaneous documents, i.e. the June 24 letter from the Council that was the product of that meeting, indicate that Miss Tucker's recollection is in error as to her alleged request for no development at all west of the Oast. The only possible alternative is equally unfavourable to the Council, that Council planning officers considered any such suggestion by Miss Tucker went too far and was without justification, and accordingly they set the power lines as the recommended outer perimeter of development. What is indisputable is that the pre-app advice in this respect has been adhered to, but the goalposts have been moved. Secondly, the current proposals do not incorporate a roadway west of the Oast. The cycleway footway is on the other side of the significant slope below the plateau that Dr. Mealy spoke about, and will not be noticeable while in the vicinity of the Oast. Thirdly, the northwest corner block in the 235 unit proposal has been removed. The pre-app letter did not request removal of any and all housing along the northern boundary of these fields. And even if that's what it meant, despite the language of the letter plainly not going this far, there is no heritage justification for such a request, as I'll come back to below. GPA 3, paragraph 38, indicates that heritage enhancements include, firstly, removing a detrimental feature and revealing a lost historic feature, secondly, introducing new views, and thirdly, improving public access to or interpretation of the asset, including its setting. Considerable weight should be given to the creation of new and very attractive views of the Oast in a retained open setting, as well as the removal of car parking and power lines from the Oast's immediate setting, these features currently being seen prominently in views to the Oast from the west. The above errors and inconsistencies lead the Council to a grossly exaggerated conclusion that the alleged level of less than substantial harm caused by the appeal scheme is materially the same as the 2023 appeal scheme. And that apparently is factoring in the enhancements which Ms Tucker acknowledges. So in other words, you've introduced some enhancements, and even with those enhancements, we say that the harm is essentially the same. And as I say in my closing submissions, once one gets back to the real world, that is just simply not a credible position. The two illustrative schemes can be seen next to each other in Dr. Mealy's evidence. They are chalk and cheese. It's even more baffling how Ms Tucker has moved from assessing the 2023 scheme as being capable of being brought forward without harm to contending that a scheme which has removed 100 homes, established a retained open area to the west of the Oast, which is 3.5 hectares in size, and where the proposed homes are peripherally located and are not suggested to compete visually with the Oast when seen from the west, how that causes materially the same level of harm as the 2023 inspector found. These confusions and exaggerations undermine the weight that can be attached to Ms Tucker's analysis. While seeking to avoid undue repetition, I briefly address the particular aspects of the appeal scheme which attracted the Council's criticisms at the inquiry. Housing southwest of the Oast. As above, the appeal scheme adheres to the pre-app advice. It's unfair and reasonable that the Council has suggested otherwise. Council has no other candidate as the easement to which development should be drawn back to. The letter obviously meant that development should remain east of the power line easement, a recommendation the appeal scheme respects. Anyway, these houses are distant from the Oast. The nearest one is 110 metres away and peripheral to its setting. They do not compete in any way. The substantial separation will be evident in any views from the hospital car park or allotments. Indeed, there will be no material difference in views from those locations, even if the Redmond 26 units are removed, because the remaining homes will still be seen, but peripherally and at a considerable distance from the Oast and going down the slope. And can I just pause there, sir, and point out an error in the Council's closing submissions. At the end of paragraph 52, it's claimed that in re-examination, Mr. Brown was invited to state that the buildings would not be visible from the west. This is with removing the Redmond 26.
So it's not with removing the 26.
All right. Well, in that case, the Council's closings are simply wrong, because that's never been our position, and it's simply not the case that the houses south of the Oast will be invisible from the west. That's never been our case. Our case has been they're 110 plus metres away. They're a completely peripheral part of the setting. They don't in any way compete with, they won't be in front of, they won't break views towards the Oast. You'll see the Oast with an enormous green area in front of it. The point I was in fact exploring with Mr. Brown for his evidence in re-examination was this, that being the position in respect of the appeal scheme, would the views be notably any different when seen from the west? Already as it is, the Redmond 26 can't be seen from the vicinity of the Oast at ground floor level. So would it make any great difference to views from the west, from the hospital car park, with or without the Redmond 26? And the clear position I would invite you to conclude, and I think this was Mr. Brown's evidence, is that you would see essentially the same view, because the first house will be essentially the same distance, at largely the same orientation, and then the other houses will be seen falling away effectively further to the south and then down the slope. So lopping off the Redmond 26 essentially just doesn't change that view in any material way. It'll be a tiny bit more green and the houses will be a tiny bit further away, but the view will be composed exactly the same. So that's frankly a fundamental point as to why the Redmond 26 doesn't actually change the position in harm terms, assuming that you agreed that there was harm in the first place, and lopping them off doesn't make this dramatic difference to the alleged level of harm caused. So if I revert to my text, I'm about 6 lines down on page 6. Further, at ground level in the vicinity of the Oast, surrounding development, in particular the large commercial buildings south of the Oast, blocks views of these proposed houses. Some of them, Dr. Mealy predicted around 10 to 12, could be visible from the staircase, in any event a functional view as one passes through the staircase into the Oast itself. But even then, they will be seen peripherally in a context where other modern development on the eastern side of Uckfield is clearly visible, indeed directly in view, as one climbs the stairs. That's what you look at if you're looking, unless you're looking at your feet, you're looking at Uckfield. What will really be noticeable is the retained open 3.5 hectare field due west, especially with the removal of the car parking in the immediate vicinity. If considered appropriate at reserve matters stage, this was a point Dr. Mealy made at the round table session, further separation in visual and other terms could be achieved with landscaping strategically located in the 110-metre gap between the Oast and the nearest proposed house. In relation to the staircase views, there's a further clear exaggeration by Miss Tucker at her paragraph 6.18. This claims that the views, in her words, afford a similar outlook to that which would have been gained historically, with clear separation from the urban edge of Uckfield and the fields remaining pastoral in use and character. This is just simply not accurate. Historically, you didn't see Uckfield at all. Remind yourself, sir, of the 19th century plans. It was miles away at that point. Nor did you see the rest of the large commercial buildings in the farm or the car park. Also, the fieldscape and pattern of enclosures and paddocks has changed significantly, as Dr. Mealy explained. This is another clear error by Miss Tucker. Housing northwest of the Oast. As above, retention of the proposed 10 houses in this sector accords with the pre-app letter. Anyway, Tucker 6.10, this isn't a point that featured in the Council's closing submissions, quite surprisingly, given the recitation of much of the rest of Miss Tucker's evidence. But Tucker 6.10 accepts that the proposals for hopper huts will likely reinforce local distinctiveness. That's accepted in her evidence. Yet still these homes are objected to. The homes are so peripheral and distant, 130 metres plus from the Oast, that the Council has been unable to articulate any credible way in which the Oast's significance is diminished by these homes. The objections in Miss Tucker's evidence are not actually heritage-related objections at all. If you reread them, sir, I'd invite you to do that. They're general design and density arguments. This is a clear example, again, of the Council explaining what GPA 3 Step 3 requires and then failing to apply it. In any event, the houses are not visible from around the Oast, or unless you walk 30 metres west across the car park. And they could have a landscaping scheme to their immediate south at Reserve Matters stage, further undermining the credibility of any suggestion that the Oast's significance would be diminished. On to the roundabout. The key point here is that, as Dr. Mealy's written and oral evidence explains, and which the Council has not attempted to answer, current views from the B2102 access do not allow a meaningful appreciation of the Oast in its former agricultural setting. There's no view of expansive surrounding fields, and much of the Oast is blocked or distracted from by the substantial utilitarian commercial buildings. The Council's assertions that there would be any change in the extent to which the Oast is visible on arrival are flawed and based on a clear misunderstanding of the highway drawings, which disclose no material or relevant levels changes. And so just on levels changes, you'll remember we were told at the RTS about a dramatic 4 or 5 metre relevant levels change by Miss Tucker. We did point out through Mr. Stevens that was a complete misreading, a misunderstanding of the plans, and that there was no such dramatic levels change. And you'll note that the Council hasn't maintained that point in its closing submissions. It was clearly another error, another clear error on the part of Miss Tucker. The Council's pre-app letter did not raise any heritage objection in respect of access. This is another clear example of the goalpost moving. The retained 3.5 hectare public open space to the west, as stated by Dr. Mealy in his proof at 6.20. I'm advised that the intended maintenance regime will not be intensive. It will be planted with wildflowers, trees and an orchard. The planting will be managed to maintain views of the Oast House from the west and views from the Oast House to the west. Neither the existing paddock use nor the one that's proposed is for arable crops, which is likely to have been the case when it was built. So, I do not think the proposals are any less appropriate than the use of the land for ponies and hay cutting. The landscaping would, in my opinion, be more attractive than the current one. And that is the clear answer to all these points the Council makes about a purported concern relating to managed parkland character. As for other objections raised by Ms Tucker, the SUDS features are distant from the Oast, over the slope, and will be no more than shallow and vegetated depressions, and the cycleway footway will similarly be set around 16 to 18 metres below the level of the Oast, over the slope for the most part, and thus not noticeable to any appreciable extent from its immediate setting. As has been said elsewhere, the Council's analysis fails to apply GPA 3 Step 3 properly, there being no coherent explanation how the significance of the Oast is said to be harmfully diminished by these limited setting changes, which will sit lightly on the land at some considerable distance from the Oast. Lighting and tranquility. These complaints are, again, without merit. The Oast is presently not appreciable at night, so it's impossible to understand how its significance is diminished by lighting of the access or the footway, cycleway. Indeed, if the Oast were visible from distance at night, that would be a benefit. That would be a further enhancement, new views created. But it won't be the position in any event. This is yet another example of the Council ignoring GPA 3 Step 3 or misunderstanding it as focusing only on changes to setting and not consequential diminutions to significance. Further, Ms Tucker 6.24 exaggerates by claiming the setting of the Oast will be significantly diminished by appeal scheme residents wandering across the POS to the west. This evidence is strange anyway, but it takes no account of the commercial uses which abut the Oast to the east, nor the existing car park to the immediate west, which part of the POS would replace. For these reasons, sir, you are invited to agree with the views of Dr. Mealy and, consistent with the effect of the Council's own pre-app advice, conclude that the appeal scheme will not result in any harm to the significance of the Oast. Accordingly, there's no less than substantial harm to weigh in the balance. But even if you do consider that there is some less than substantial harm, for the same reasons, it's at the lowest end of the scale. On any basis, even if the less than substantial harm were found, it's substantially below the level of less than substantial harm concluded by the last inspector in relation to the 2023 appeal scheme, which obviously, as you've seen, effectively wrapped around the whole of the west of the setting of the OAST. On to the heritage balance if it arises. As I said in opening, the heritage balance evidence is all one-way traffic, even affording, as you must, considerable weight and importance to any established heritage harm, whether at the very bottom end of the scale or amounting to moderate harm, for which Ms Tucker contends. The Council's worsening housing picture and the other material planning benefits of the appeal scheme support a conclusion that benefits outweigh. There's no good reason why the appeal scheme should be treated differently than other recent proposals in this district. In particular, the Council has been unable to explain coherently how its resistance to this appeal is consistent with the recent Buxted appeal decision relating to a nearby site. In that case, less than substantial harm at the moderate level, i.e. the Council's case here, was found to a Grade 2 star listed building as well as to a Grade 2 star registered park and garden. But these impacts, along with low, less than substantial harm to other designated heritage assets, were outweighed by the benefits of a 49-unit scheme. It's clear from MPPF 212 that the more important the asset, the greater the weight should be, and accordingly, and consistent also with the Framework 213, the less than substantial harm in that case should have attracted more weight than even the Council contends for here. Yet the benefits of a mere 49 new homes, around 25% of the scheme here, outweighed. Similarly, the officer report for that scheme found moderate, less than substantial harm to each of the two Grade 2 star assets, and notwithstanding strong historic England representations, still recommended that benefits outweighed. The Council has not made clear at this inquiry why the appeal scheme has been subject to different treatment in circumstances where, firstly, the harm alleged is less because the OAST's status is Grade 2, and secondly, the housing benefits are 4 times greater. More broadly, sir, you're invited to agree with Mr Brown that the cumulative benefits of the appeal scheme should be afforded very substantial weight in the heritage and any other planning balance. Firstly, the provision of up to 190 new homes. There's an acute housing deliverability crisis in this district, and there has been for a very considerable period. This is common ground with the Council, Mr Redman having realistically accepted in cross-examination that the Council has a housing crisis which is acute, deep and long-standing. Further, it's agreed with the Council that substantial weight should be accorded the provision of new housing. See both of the statements of common ground, and I've given the references. Mr Redman suggested some downgrading of the weight to be attached. In this regard, Mr Redman found himself disagreeing with both SOCGs, including one that he had signed himself. This peculiar evidence undermines the credibility of Mr Redman's judgment, and it should be disregarded with the Council held to what it had agreed in the two SOCGs. Moreover, the Council can only demonstrate a 3.6-year supply for 24-9. The shortfall is 2,270 homes that should be and will not be delivered. The position has worsened since the last appeal, when, as you see, the shortfall was 1,579. The shortfall has increased by around 700 units. The Council has been a 20% authority for at least the last 4 years, and it has not had a 5-year supply for over 9 years. The August 2022 Horam decision at paragraphs 19 to 20 recorded that the Council had lacked a 5-year supply for more than 6 years, and that was 3 years ago. Mr Brown's unchallenged evidence to the inquiry was that such a lengthy period of not having a 5-year supply is very unusual. A reasonable opportunity for new housing, such as the appeal scheme, must be taken. This is a highly constrained district. 60% is national landscape and national park, but there's also the Pevensey Levels Ramsar site and the Ashdown Forest SPA SAC, and no doubt many rural areas where substantial housing development would not be locationally sustainable. The core strategy acknowledges a limited legacy of PDL and records that it's inevitable there will have to be substantial use of greenfield land to meet existing and future housing needs. There is no prospect of the Council's substantial housing supply deficits being addressed in the near future, especially with local housing need now assessed at 1,433 dwellings per annum. Mr. Redman accepted as much in cross-examination. The emerging local plan is still at the starting gate, with a possible Reg 18 later this year and adoption years away. The parties agree it is to be accorded no weight for present purposes. That's in Mr. Redman's evidence. The Council has lacked an up-to-date development plan since 2018 and will not be addressing the position in the foreseeable future. As it was pithily put in the recent Buxted decision, there is no obvious remedy to the housing shortfall as the LPA continues to fail to meet the housing needs of the district. The evidence indicates that there is a persistent shortfall in market housing and an acute need for affordable housing. The Hallam Land analysis as to the assessment of what weight to attach to a housing deficit includes at paragraph 51 the following: the weight given to the benefits of a new housing development in an area where a shortfall in housing land supply has arisen is likely to depend on factors such as the broad magnitude of the shortfall, how long it's likely to persist, what the local planning authority is doing to reduce it, and how much of it the development will meet. All these factors reinforce the depth of the crisis afflicting the council and those seeking homes within its area. The magnitude of the shortfall at 2,270 is very significant, and I'm going here through these factors, sir. So first of all, magnitude. A 5-year shortfall has persisted for nearly a decade, and there is no foreseeable end in sight. Nor is the council doing anything meaningful to reduce the deficit or that might have this effect in anything like the foreseeable future, as it continues to fail to meet the housing needs of the district in the Buxted inspector's damning assessment. Of course, we hear from Mr. Redman, and again this reappears in the council's closings. Well, we're granting lots of permissions. I don't know if that's the case or not. There's certainly no analysis of what permissions have been granted within what time frame. In any event, the important analysis is the assessment of what deliverable supply the council can show. And they're miles behind where they should be, and that's been the case for the last decade. The council appears content to operate with an out-of-date development plan, making no serious effort to pursue a new local plan that grapples with its housing requirements or the housing needs of its population, while making regular appearances on the appeal circuit. In Mr. Redman's words during cross-examination, there is no obvious remedy for the housing shortfalls. In other words, it's essentially given up on trying to address its housing requirements anytime soon. The appeal scheme will make a significant contribution to housing needs, with 190 homes equating to just under 10% of the district's 5-year deficit. And so I deal with deliverability issues relating to the appeal site later on when responding to third parties, because up until yesterday there hadn't been any issue raised about deliverability by the council. With respect, the council then piggybacked on a point raised by third parties, and it's now morphed into something referenced in the council's closing submissions, despite there never having been a disagreement about that before, there not being any evidence from the council about it. Again, that's a disappointing way in which that evidence should proceed, but substantively there's no good reason to conclude, other than Mr. Brown's analysis on the basis of his many years of experience of development schemes, that this whole scheme, or the significant part of it, is capable of coming forward within the next 5 years and contributing to current deficits. 10.6. It should be noted that Mr. Redmond confirmed in cross-examination that his evidence had disregarded as irrelevant the fact that the council had no obvious remedy for the housing shortfalls. This is not only a breach of the Hallam Land Court of Appeal decision, it also puts into fundamental question the output of his heritage balance, which he admitted was relatively close, and which could plainly be reversed by taking proper account of Hallam land and or by one of the many other flaws in the council's heritage and planning evidence pointed out in these closing submissions. The council's apparent approach that significantly boosting the delivery of homes is something that should be addressed in other districts but not in Wealden should be rejected. Moving on to affordable housing and the provision of up to 67 affordable homes. Again, it's agreed with the council that substantial weight should be accorded the provision of up to 67 affordable homes. This is consistent with appeal decisions in the district. The Horham decision attached very significant weight to 13 units of affordable housing, and the Framfield decision attached substantial weight to 20 affordable homes. Once again, the crisis in affordable home provision is deep and long-standing, with the council without the council offering any plan for the future. It should also be noted that in policy terms, the importance of providing affordable homes is greater than it was previously, with the December 2024 MPPF at paragraphs 11D and 20A now making express reference to such provision. The provision of a substantial number of new affordable homes against such a background is not a debating point. It's something that has real-world and positive benefits for people. It's well established that not providing the neediest in our community with a decent place to live causes deep social and health-related consequences, in particular for children. This was eloquently put by the Sons Place inspector, who said at paragraph 88, accepting evidence from Shelter, the consequence of not providing enough affordable homes affect people. Being able to access good housing has a bearing upon everyday life, and there are socio-economic effects such as financial security and stability, physical and mental health, decreased social mobility, and adverse effects on children's education and development. The affordable housing situation has also significantly worsened from 2 years ago. In particular, the under-provision against LHNA requirements is now 2,947, and this has accrued in just 5 years. The under-provision is 1,119 worse than at the time of the last appeal. The affordability ratio graph in SB5 shows the council's rate remains well above both England and South East averages. Another demonstrably worsening indicator is the number of households on the council's waiting list. This is now 1,071, and apparently the trajectory is rising, and it's around double the figure from 2 years ago. Alarmingly, the number of homeless has risen from 13 to 137, a 1,000% increase in just 2 years. As the homeless are a priority need category, this comparison alone shows the extent to which the council is failing its population in need of affordable homes. Accordingly, the council rightly accepts in the SOCG, it's agreed there's a very significant need for additional affordable homes. There is a chronic under-delivery of affordable housing in the district. Highway safety and sustainability benefits. This matter was not taken into account by Mr. Redmond. This is a further manifest flaw in his relatively close heritage balance. Mr. Brown considered that these matters should be accorded at least moderate weight, in particular and focusing on matters which bring benefits to existing local residents and so go beyond mere mitigation for the scheme's impacts. Firstly, speed reduction on the 2102. The new roundabout will reduce speeds along the 2102. This brings benefits for existing drivers and cyclists using that road, and for residents with access driveways onto this part of the B2102 as well. The appellant anticipates there will likely be speed reductions of about 5 miles an hour, with speeds therefore reducing to 32 miles an hour eastbound and 31 westbound. This analysis accords with experience within the county where similar or lesser interventions have resulted in a comparable range of reductions. That's all in Mr. Stevens' evidence. Further, the DFT circular which he quotes, confirms, summarising research, that every 1 mile an hour reduction decreases collision frequency by 5 to 6%. The roundabout is accordingly likely to reduce collision frequency on the 2102 by 25 to 30%. It's of note that the county did not dispute any of the above analysis set out in Mr. Stevens' proof during the RTS. Secondly, substandard visibility at the current Bird and Eye Farm access from the 2102. As set out at Mr. Stevens' 4.7 to 4.9, visibility to the left is 52 metres, when it should be at least 160, and forward visibility on approach to the turning is 78 metres, when again it should be at least 160. The foregoing analysis was not disputed by any party. The county indicated at the RTS that they were not overly worried by these matters, taking account of the recent lack of accidents. This is a surprisingly insouciant attitude. The past is not a guarantee as to the future. It's hard to imagine the county approving a new access with comparable dimensions and for a comparable mix as currently uses the Bird and Eye Farm access. More realistic is Mr. Stevens' concern that the access junction is an accident waiting to happen. The clear safety benefits of the appeal scheme should be afforded corresponding weight. Other safety betterments. Other safety, not just convenience, benefits are firstly ensuring no occasion arises where an HGV is left waiting for another vehicle with its trailer protruding into the B2102, and secondly providing a footway cycleway route within the site so that existing residents have a choice of cycle routes and more importantly no longer have to walk along the 2102's carriageway, something which is demonstrably not for the faint-hearted and would be insane to attempt in anything other than single file and without children. Fourthly, bus and other improvements in locational sustainability. The Section 106 obligation secures a substantial contribution to keep bus route 29 going for the foreseeable future. It is otherwise, as you know, sir, under threat, as well as upgrades to local bus stop infrastructure and footway upgrades along Framfield Road. Next, heritage benefits. The heritage enhancements which the appeal scheme will bring and which fall within the terms of GPA 3 paragraph 38 have been enumerated above, principally the creation of new highly attractive views of the Oast in a retained open setting, and secondly the removal of detracting features, the car park and the power lines, which do presently intrude on views to the Oast from the west. Indeed, have a think please, sir, when you go and visit the hospital car park area and you look towards the Oast. Obviously, I've asked you to consider.
Yeah, I've done that.
Yes. In that case, when you write your decision, can you reflect on this point? And indeed, this is made evident from all the photographs that people have put in evidence from that direction. In every single one, you see a whole host of car parking, sometimes with vans, sometimes with numerous coloured cars in front of the Oast. And again, as I say, remind yourself of the photos, please, of that. It's really quite striking how noticeable the car parking in front of the Oast always is. It's a clear detracting feature and a clear benefit of the scheme that will be removed. Other planning benefits of the appeal scheme, going to my paragraph 16. There's a basket of other planning benefits too, and to each of which both Mr. Brown accords moderate weight and Mr. Redmond mostly agrees. As to these, SANG and POS provision is well in excess of policy requirements. The SANG requirement is 3.65 hectares, but we're providing an excess of 3.95 hectares. There's also 5.2 hectares of other POS, so the total open area provision is 13.9 hectares, just over 70% of the appeal site. The SANG POS will be available to serve existing residents in the area as well as scheme residents, hence the county requirement for 9 parking spaces. BNG, I've given you the latest figures there, so I'm not going to read them out, miles above the 10% benefit which is required. and Mr. Brown's analysis that this attracts moderate weight is entirely justified. Economic benefits, the specifics we went through yesterday with Mr. Redman, and I've retained the reference to where those can be found. None of them were in dispute. The council's endemic and chronic under-provision of housing means that the economic benefits of new housing are not being delivered in this district in anything like the quantum that they should be. And ancient woodland benefits, again, it's agreed that the introduction of a management regime for the surrounding ancient woodland is a moderate benefit of the scheme. For the above reasons, the overall package of benefits arising from the appeal scheme is cumulatively very substantial, and it's respectfully contended that any less than substantial harm, if there is any, is outweighed, indeed outweighed by a considerable margin. However matters are looked at, heritage is not a strong reason to refuse this much needed appeal scheme. Going on to third-party points. Although third parties raised numerous objections which occupied a considerable amount of time at the inquiry, they can be addressed here reasonably briefly, having been commented on at some length in the appellant's written evidence, as well as during the first 2 sitting days of the inquiry. It was disappointing that some objectors were unable to agree that substantial weight should be given to the appeal scheme's proposed affordable housing, with one objector repeatedly refusing to answer the question, latterly due to concerns the phrase may have some hidden meaning. Further, the substantive points pursued by third parties at the inquiry are all points with which both the council and statutory consultees disagree. In short, provision for cyclists. The access arrangements have been found to be safe and appropriate by county highways and the council, in particular for cyclists. Indeed, the arrangements for cyclists are particularly suitable because vehicular speeds will be lower, and the particular compact roundabout types have been selected because guidance deems them the most cycle-friendly. The off-road route down Birding Hill is a demonstrable benefit for cyclists and pedestrians alike. Swept paths. Similarly, third-party points on swept paths are without merit and are not supported by county highways or the council. For example, the refuse vehicle visits the site once a week, and the short distance where it crosses the centre line will have slow speeds, very low usage, only 10 houses connect, and clear intervisibility. As the inspector will appreciate, this is a common scenario around the country, and it's not necessary to over-engineer new roads to allow for one weekly vehicular movement. In the same way, there is clear visibility for vehicles arriving and leaving the Birding commercial complex, and the proposed arrangements involving single track working for about 30 metres in what will be a 20-metre zone, a 20 mile an hour zone, and in a location which is not part of the route to or from the residential areas, are a clear betterment over the present position, where single track working applies over 125 metres and could involve HGVs stopping on or backed up into the 2102 with its current 60 mile an hour speed limit. Locational sustainability. The 2023 appeal determined that the site is locationally sustainable for substantial residential proposals, and the council and county highways agree that this conclusion holds good for the appeal scheme. It's not reasonable for third parties to revisit these clear conclusions. Further, the basis on which they seek to do so is to repeat verbatim arguments made in 2023, which were rejected, namely the occasional short-term flooding once a year or so for an hour or so, which occurs on Framfield Road near the access to the hospital. Our full response on these points is set out at page 2 of SB2 and is exactly what we said last time. The 2023 inspector, fully apprised of these matters, concluded that the appeal site was locationally sustainable for substantial residential proposals. Surveillance of the footway cycleway. Mr. Stevens' MS5 demonstrates that there will be surveillance, as well as a perception of surveillance over this route from 3 directions. The houses to the northwest, as I mentioned yesterday, so it's obviously one of the many benefits of those houses. The houses to the southwest and the commercial buildings surrounding the Oast. There will accordingly be no deterrence from using this route into Uckfield for either pedestrians or cyclists. The council and county highways agree the route is suitable and that the footway cycleway contributes to the site's acceptable locational sustainability credentials. And again, if one just pauses there to have a think about the council's apparent generosity in putting forward its suggestion, well, just chop off the Redmond 36, the 10 at the north and the and the 26th at the southwest. And obviously the heritage balance will flip clearly in your favour. The council generously concedes. What none of that takes into account are all the consequential matters that would need to be reflected on, which nobody's assessed. In particular, whether that would make significant parts of the footway cycleway no longer subject to surveillance. Obviously, there'd be no surveillance from the north anymore, and surveillance from the southwest, nobody's looked at this, may well be significantly reduced in respect to the northern part of the footway cycleway. So do please be very cautious about the apparent generosity, sir, of the council's concession. We'll just lop off a bit and we'll give you planning permission next time around. It's an invitation to be back here for round 3, having arguments about different matters. Sir, it's not quite as simple as the council presents. Obviously, that's very much a secondary argument. My principal argument is that both those housing areas are entirely justifiable because although there's a change to the wider setting, it's not a change that impacts the significance of the Oast, and in particular the Redmond 26 in the southwest. You'll see the housing outside Mr. Redmond's red line just as readily from the west as you will the housing in the red line. Right, back to my text. 19.5, the illustrative drainage strategy. These third-party concerns were exposed as misguided, quite apart from being based on a failure to grasp that the drainage strategy is only illustrative at this time. Further, the illustrative drainage strategy has led to no concerns being raised by the LLFA or the council. It's plain that there's space to protect the ancient woodland 15-metre buffer by way of a fence separating the limited works required to prepare the shallow depressions that will constitute the suds basins and accompanying swales. Hydro breaks and pipe sizing, etc., control release of surface water into the Framfield stream at Greenfield runoff rates entirely in accordance with normal practice. The sequential test. This is a further contention of third parties lacking in any substantive merit. In summary, first of all, based on the December 24 framework, there is in fact no need for a sequential test. As you know, we prepared this 6 months before that. The new policy on this is at Framework 175. It's materially different from the policy applicable previously, and I've, in the footnote, given you a cross-reference to where you can find that earlier policy. MPPF 175 provides that a sequential test is not required where a site-specific flood risk assessment demonstrates that no built development within the site boundary, including access or escape routes, land raising or other potentially vulnerable elements, will be located on an area that will be at risk of flooding from any source now and in the future. As is demonstrated in the update paper accompanying the Wheatcroft application at CD 5.12, none of the built development or the access escape routes or potentially vulnerable elements or minor level changes are in areas at flood risk. And that, of course, is because the only area of flood risk where any works are required is the tiny area at the westernmost part of the site where a new drainage pipe is to be laid underground connecting subbasin 4 to the Framfield stream. This pipe is obviously not a potentially vulnerable use, and its location in flood zone 3 does not introduce any risk to personal property. Indeed, the pipe is clearly flood control infrastructure and thus water compatible development within the meaning of Annex 3 of the MPPF. There's no requirement to do a sequential test where a short length of underground pipe is the sole works within a flood zone, whether under MPPF 175 or otherwise. Secondly, it's a matter of planning judgment whether any sequential test, if required, is satisfactory. Here the Council has twice considered the position and has confirmed in both planning SOCGs that the submitted sequential test is satisfactory. Third parties' methodological quibbling provides no credible basis for a different conclusion. Smaller sites do not fall to be aggregated as a series unless there is some connection between them. See the Mead and Redrow decision at para 110. The appellant is not aware of any such connection, nor is the council, and third parties have produced no evidence to the contrary, nor was any third party here to cross-examine Mr. Brown about any of these matters, as they would have been entitled to, and put any points, if they had any, to that effect. Similarly, the 25% range approach is entirely acceptable as a matter of principle, see Yatton, and there's no third-party evidence that the appellant's approach has allegedly resulted in some significant and preferable site being overlooked. That was confirmed, indeed, on day one. Further, although one objector complained that the sites which the sequential test showed to be more favourable in flooding terms had not been assessed, this claim was factually inaccurate. It was based on a failure to realise that the sequential test and the sequential test updated SB3 were both accompanied at Appendix B by a detailed analysis by Mr. Brown explaining why those sites are not suitable at all or not developable in the time frames applicable to the appeal scheme, those being the relevant MPPG tests. And again, same point applies. No third party was here yesterday to cross-examine Mr. Brown and to suggest that his analysis of those sites not being suitable or reasonably available was inaccurate. Finally, even if contrary to the above there were a need for a sequential test and the test put forward were defective, this does not amount to a strong reason to dismiss an appeal in the absence of some real-world flood-related dangers. See Inspector Woodward's approach in the Faversham decision at paras 99 and 101. This considered analysis has returned the focus to the fundamental question as to whether there is any actual flood-related risk. Here there is none, and not even the third parties suggest otherwise. They simply pursue a hyper-technical objection. Finally, one objector raised concerns about the timing within which housing can come forward at the appeal site, and as I've already mentioned, the Council now belatedly piggybacks on that concern. These concerns appear to be undermined by a lack of appreciation as to how a developer builds out a site once consent has been granted, and the ability to address different matters concurrently. Mr. Brown's evidence was that there will be completions on site within around 2 years of consent, and that progressing at around 50 to 60 units a year, the site will be built out, or all but built out, within 5 years. That is a normal development trajectory. Anyway, it's unclear where this point takes third parties. There's a housing crisis in this district now, and for the last decade, with 5-year shortfalls well over 2,000, and no plan to speak of to address these deficits. The appeal scheme's houses are desperately needed, whether they're all built out in 5 years or in a slightly more elongated time frame. The Council should not be permitted, in the Buxted Inspector's words, to continue to fail to meet the housing needs of the district. In conclusion, Sir, Heritage does not present any reason to refuse this scheme, let alone a strong reason to do so. This is a clear case where the tilted balance supports the grant of planning consent. The benefits of the appeal scheme are very considerable. The harm is in reality non-existent, but it certainly does not significantly and demonstrably outweigh these benefits. For the above summary reasons, Sir, you are respectfully invited to allow the appeal and grant planning permission.
Thank you, Mr. Tabachnik.
Thank you, sir.
So, in terms of what happens next, by the, whatever it is, 2nd, 4th of August, whatever you said it, 6th, I will receive the signed and dated Section 106 agreement. We know the conditions. I know I've got to choose between one or the other version of the Grampian condition. Yeah. So I'd just like to thank everyone for their contributions to this inquiry. Thank you very much. Thanks. Just to say, this has been one of the most pleasant and easiest appeals I've had to deal with recently. Not in terms of the issues, but in how it's been conducted and how things have been progressed efficiently. So thank you for that. Thank you.